Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney for free. We have a question here. I don't know why I'm being this way. We have a question here from YouTube user Charmed1315. That 315, I suspect, references area code 315, where I went to university. I'm more of a 607 lad myself, more of that Binghamton Ithaca 607. But listen, let's be honest, none of us are 212, which is a great song. But I should probably not reference the lyrics nor the political or philosophical opinions of the artist on this channel. That wouldn't be deeply counterproductive. But that being said, I digress. Charmed1315 asks us, I have a question. I'm upstate, I assume upstate New York, based on that 315, and recently received my determination of probable cause for discrimination for failure to engage in the interactive process. My attorney said she's trying to get a settlement hearing, and that's the last I heard a little over a week ago. I'm wondering what kind of timeline this may have, and what are the potential outcomes. Could you make a video addressing probable cause determinations in disability discrimination? I went with the EEOC route, and they crossed out with the New York State Division of Human Rights. All of it was done online. I feel like assuming a check is on the horizon is jumping the gun here. Not to mention, just getting this far took a year, and I had to prove my case to my attorney to even get one. Everyone in Ulster County said, call the city. We don't do that up here. Thank you for what you do. My pleasure. And the info you provide that should be more easily available and understandable to the general public, but is not. Yeah, I agree. Listen, this stuff should be out there more. Employees should know their rights. Nothing is in plain language. You have to cross-reference everything with legal textbooks and use other cases to prove you have one. It is ridiculous that there's no plain language guidance out there. You're wonderful for this. Well, that's really kind of you to say. Thank you so much for saying that. I hope I can provide the same service for you in this moment. All right, let's go through these questions one after another. I saw a specialist for the cough, by the way. Good things on the horizon for the cough, I believe. Now, first question. What is the timeline of events after you receive probable cause from New York State Division of Human Rights? All right, so listen. Things start to happen fairly rapidly when you receive probable cause from the State Division of Human Rights. You're going to start having conferences, often on the phone, telephonic conferences, where, listen, an administrative law judge, who is not generally the administrative law judge who will hear your case, will do things like have scheduling orders, talk about discovery, and push settlement. Now, the timeline for that, those calls usually take place within 2 months of you receiving probable cause. And the whole thing, on average, you're going to get a hearing, your 2-day hearing within the State Division of Human Rights, which is what, just to be clear, when you receive probable cause, what they're saying is you get a hearing. There's no guarantee that you get a hearing within the State Division of Human Rights when you file with the State Division. But when you receive probable cause, it means they have qualified you to receive a hearing, which is a good thing. It's a very good thing for you. And receiving probable cause and having that hearing coming up can often push settlement prospects for your case, so that's very advantageous. My goodness, sorry. Now, what? That's the timeline. What are the potential outcomes? Okay, so you could settle your case. You could go to hearing and win your case. You go to hearing and lose your case. Or, if you act swiftly enough, you could pull your case out of the State Division of Human Rights and go on to federal or state court. Potentially. Those are the possible outcomes. I know that's very broad, but that's the reality of your situation. What's next? Could you make a video addressing probable cause determinations in disability discrimination cases? Yes, we're doing it right now. So, probable cause in any kind of discrimination case or in a sexual harassment case in the State Division of Human Rights in New York will generally raise your prospects of settlement, will qualify you for a hearing at the State Division level, and is generally a positive thing for your case. You go on to say, I feel like assuming a check is on the horizon is jumping the gun here. Super duper yes. Super duper check is not on the horizon. A lot of things would have to happen. So you could reach a settlement. You could agree, and that would then mean that a check could be on the horizon like 28 days later in New York, which is swell if that's what you want. But you would have to have a negotiation of some kind. The other side would have to make you an offer, and you would have to accept it. Now, also, that check, your attorney is likely going to get a cut if you're on a contingency. So keep that in mind as well. And that is true for any protected class of discrimination or sexual harassment in the state division. Probable cause is a good thing for your case. And, you're going to start having these conferences to get ready for the hearing, and the hearing will hopefully be scheduled probably within 6 months. To your point about finding an attorney and having to prove your case to an attorney to get representation, that is accurate. That is one of the main issues in our industry is that attorneys don't listen. And I have a lot of videos on the channel about this, but attorneys don't listen to potential clients. And so there's a lot of skepticism because, listen, many potential clients call us up and it's not at all a claim, or maybe they're not doing so well, or maybe they just want to scream at someone, or maybe they want to level death threats if you can't make them an offer of representation. So like a lot of attorneys in this field who are generally very overworked because there's not enough attorneys in this field. If you want to become an attorney, I highly recommend becoming an employment attorney. If you'd like to turn time and attention to detail and aggression into money, it's a great way to do it. There's way more clients than can be serviced by the current number of employment attorneys in this country, in my opinion. But I digress. Yeah, so these attorneys, they're overworked. Talking to potential clients can be really hard. A lot of them don't work at firms where there's like a built-out intake process. Like we have a pretty built-out intake process. There's a call center. There's intake professionals, who talk to people and vet cases, and then those cases go on to talk to an attorney if they kind of get through the call center and the intake professional, right? Like it's a process, and it lightens the load on the attorneys considerably, and it lets the attorneys only talk to people who have like actual claims, and that's not a guarantee we'll make an offer of representation. But it is a guarantee that the attorneys can at least take the time and do right by that person and try to help, right? Because it's not someone who's just like, hi, I want to sue. And you're like, okay, can you tell me about your case? Send me a retainer. No. Can you tell me about your case? Send me a retainer. Oh, still no. I would need to know something about what happened to you to see if I could help. I'm leaving you a bad review. Oh, okay. Well, I'm going to go ahead and hang up then. This has been lovely, right? And that's like a somewhat common interaction in this field because, listen, we're human beings. We live in a country with a kind of a poor mental health apparatus. So like those folks are in the ether trying to get help. And then also a lot of the folks calling up employment attorneys are at really desperate stages of their life. They've been through a tremendously difficult time. Someone has attacked them on the basis of their identity, or like because they want to extract sexual gratification from them, and the means by which they earn their living and put a roof over their heads and care for their families and all these things have been stripped from them potentially. So they're going through a lot, and they may not be at their best. And when you're not at your best, it can be hard to communicate in a fashion that can effectively convey what happened to you. And so to your point, Charmed 1315, a lot of these attorneys have a lot of bad experiences every week. And so when you call them up, they're skeptical. And that's not great, because people who should be helped don't get help very often, and that's a problem, right? So, not to be Bill Clinton about it, but I feel your pain, right? I mean, it's a problem, and I can't fix the industry. I can fix this firm, and I think I have, but I can't fix anybody else, and we're doing our best, but we can't fix the industry. Like we're adding 3 attorneys this month. And that's one of the biggest challenges for us, is finding the kind of attorneys that we really believe will do right by our clients and run cases the way we want to run cases, and maximize value, reduce risk, really earn our fee. Like that's the ethos here. And I think we found 3 people, 1 partner level litigator and 2 younger associates who are really going to live up to that ethos and really going to be true believers and like do the work, and very excited about that. But you know, 3 attorneys in the scheme of the world of employment law nationwide is, you know, is not even a drop in the bucket. So we can't fix the industry, but I agree with everything you're saying. And yeah, the information is not available, to your point. You go on to say the info you provide should be more easily available and understandable to the general public, but it is not. Yeah, 100%. I mean, there's a reason why I make these videos, and these videos get watched more than more complex videos, right? There's a lot of good attorneys making videos, but I'm a bit of a simpleton. You know, I'm a little trailer parky, and so for me, discussing these laws and discussing this industry, the way I think and communicate is often more accessible to folks. You know, and it's not. I'm not. Listen, there's nobody over here saying I'm dumbing it down for you. Like, no, this is how I think of this industry, right? Like, my understanding of this industry is through the lens of my life, and I'm a little trailer parky, right? So, you can very much understand employment law through that lens, right? You don't need big words. Employment law is not rocket science, but often it's presented as such. And I think that's a mistake. I think it's a mistake for the attorneys who are making content, presumably because they either want to help folks or get clients, and I don't care which they're doing. I respect both. I originally started this channel to, you know, help people because I was concerned about how expensive our firm had gotten, and then kind of like against my will and out of dumb luck, it turned into like a channel that generates clients for our firm. And that was a weird experience, but kind of a unintended consequence. But, you know, I would highlight that, like, perhaps, if you look at the channels that do well, fight employment discrimination, Brannigan Robertson, this channel, those tiki-taki attorneys who kind of just lie about everything and give, like, half-formed thoughts that don't make sense. I'm not referencing anyone specifically, but, like, a lot of the TikTok employment law content that I see is like sitting in a car with your head bobbling, playing the bubbles of discrimination. It's like, okay, how did you help that person? Or like, listen, there's one guy with a really, really big face who just says things that aren't true a lot, but like they get people fired up, right? And you're just like, okay, but that's okay. I mean, you're just lying to people? Like, I presume he knows. Maybe he doesn't. But, like, he's just out there saying things that are nonsense. And that's the other end. Like, it's super accessible, what he's saying. And, like, dancing to employment law stuff is also super accessible. It's bite-sized. It's candy. You can take it in. But, like, that format, that really tiny content format, I don't know how well it conveys some of the thoughts. There is some level of complexity. It's not rocket science, but there's some level of complexity in this field. So, like, again, fight employment discrimination. Oh my God, I'm forgetting the name of a great attorney in Seattle who has a channel. But Brannigan Robertson, who occasionally I disagree with. Like, he does great content, helping people break stuff down. And listen, even if I occasionally disagree with the video, the value is having the discourse, having the content out there, letting people go view his breakdown, and then view my response, and having a back and forth of like, well, Brannigan's real polished, and he says this, and this is how you have $1 million claim, and Vince has some other thoughts, and maybe I could look at, you know, which of these thoughts are more applicable to me, or who I might agree with, or like how I want to approach this. And those difference of opinions have value too, I think, to me at least. So, you know, those channels that simplify things and make them accessible to the general public, they do the best. And listen, there's again some channels that just say nonsense to get views and get clicks on the tiki-taki, and that's different. That's perhaps not ideal. But the sweet spot is like you make it accessible. You think of it as a gift economy, like you're just giving people stuff, and listen, that might come back to help you, it might not, but the point is you help someone, right? And I think those channels that make it accessible are the channels that do the best, provide the most value, and get the most cases launched, frankly. And that's part of what you want, right? You want employees to know their rights. Because if you don't know something's a claim, or you don't know what bringing a claim looks like, or you don't know how to bring a claim, or you don't know how to contact or talk to an employment attorney, what you ain't gonna do shit. If somebody does, right? If somebody walks in tomorrow and just starts fondling you, gender non-respective, whoever you are, and you're like, wow, that was inappropriate, that was sexual harassment, that was uninvited and non-consensual, I would like to bring a case. Well, if you don't know it's a claim, or you don't know how to bring that case, you know what you're going to do? Nothing. Not a goddamn thing. You're going to take it. And that's not right. That's not a way to live. It's not a way to earn your living. It's not labor with dignity, right? I mean, hard no. Hard pass on that. So anyways, Charm1315, I agree with you. I hope this video provided some value. This went way too long. But anyways, if this was helpful, like, subscribe, comment down below, share our channel so we can grow. I hope you get paid. I hope you get a big check. Good luck.